and these are the rights which are given to the stakeholders for the data subjects: right to access, right to correction erasure, right to seek grievance redressal, and right to nominate. Okay, so I'm not going to spend much time here because we have a dedicated chapter for data subject rights. I'm going to discuss all of them in detail, but you need to know this data subject rights which have been given here. It's limited in nature because in GDPR we have around 8 data subject rights, and the data subject rights as a concept will vary from different region to different region. But right to access, right to correction, and right to deletion, these three data subject rights are almost same, or it's a common element across most of the data privacy laws, right? So if you are setting up a global office, then these three rights are definitely are the ones which you need to be in your action items to be enable process to fulfill that. Okay, so right to nominate is something interesting that makes the even deceased people data can come into the scope of DPDP Act, because in the event of death or incapacity of a data principal, someone can actually file a complaint or DSR on their behalf, right? That power of patani in terms of how it's been being given will be clarified later. Right to seek grievance redressal. This is an interesting right, which is basically trying to lodge a complaint against your data fiduciary controllers, basically, or your consent manager, whoever is gonna that concept is yet to be clarified. So in this case, you can file a complaint, but one stark difference is that in GDPR, you can claim in the name of grievance redressal both material and immaterial damages, right? So it is quite common that you will get lawsuits from the data subjects as well from GDPR, right? You will get penalty, of course, from the authorities, but over on top of it, you might also get lawsuits from the individuals as well. But in the Indian law, they have actually taken out that option from the DPDP Act, whereas you can always approach the court of law. That is little different, right? So, but in the GDPR, you already have a provision where you can file a complaint for both material and immaterial loss. I hope you can differentiate between material and immaterial loss, where material means you incurred a financial damage or anything to you materially lost. Immaterial damage is your stress, anxiety, the whatever as mental trauma that has you incurred because of that a breach. Then you can obviously file a lawsuit against that organization, right? Those are the basic differences. DPDP Act is one of the unique laws which has called out in terms of data principal obligations as well, where the data principal should be cautious whatever information they provide to the authorities or to the controllers. It's first of the kind out of the 200 laws where you can get a penalty to a data subject. Okay, if you do any mistake in terms of providing that material information, you try to give any erroneous data, all these things, if you register a false or frivolous grievance, all these things you will be able to get a penalty, right? So that's something just to keep a tap on people not misusing these provisions, correct? But 100% people are gonna excited to exercise data subject rights when it comes to the enforcement, and you will see not thousands but maybe lakhs or maybe more than that in terms of data subject rights being raised by individuals just to fancy to see how does it work, isn't it? So that's the stage where organization needs to be more prepared, especially B2C segment. All right.